Hello and welcome to the November 2024 edition of Outline, DLA Piper's regular series of planning law updates. And today we're going to have a look at some of the case law, a bit of a smorgasbord of case law. There's no real theme running through today, just some of the cases that we think are most interesting and most relevant, not for their tricky legal points, which, let's face it, are never terribly interesting, but more for their sort of practical consequences for those of us at the cutting edge of actually trying to deliver development and determine planning applications. My name's Trevor Ivory. I'm a partner in the planning team here at DLA Piper. I'm joined today by two of the legal directors in the team, Amy Truman and Ian Graves, both regulars to Outline. So welcome back to you both. Uh, as usual, there's opportunity for questions if you're watching the live broadcast. Please do use the chat function to ask any questions as we go along, and we will do our best to answer as many as possible. We will stick strictly to the maximum of an hour, and hopefully we'll be a little bit shorter than that so that we don't keep anyone for too long. So without any further ado, let's go to our first case. And I think, Ian, you're going to kick us off with a case that follows on really from the Supreme Court decision in Finch, which we've talked about previously.
Yeah, that's right. So I wanted to talk about the Whitehaven coal mine case because as you said at the beginning, I think we were trying to focus really on things that are of real practical use for clients, and this is one that a number of clients have mentioned to me recently, as you said, coming sort of quite hot on the heels of Finch, really. So it's an EIA case, I suppose, just to sort of give a bit of very brief background. So in terms of the environmental impact assessment regulations, the key point really for understanding this case is that we have to assess the likely significant effects of the relevant development, and that includes both direct effects and indirect effects. And as Trevor says, people watching will have no doubt be familiar with the case of Finch that was in the Supreme Court last year, and that dealt with downstream impacts of developments. And in that case, the development was oil extraction, and it was considering whether the ultimate combustion of that oil, so for example, by it being refined into petrol and burned in cars, is an effect that needed to be assessed under the EIA regs. And what the Supreme Court said, sort of put it very briefly, is that where it's an inevitable consequence of the development that the burning would happen, then this would be a significant indirect effect of the development, and so it needed to be assessed under EIA. So the Whitehaven coal mine case sort of follows on from this. Unfortunately for the Whitehaven developers, the public inquiry in relation to their development, which was a coal mine in Whitehaven in Cumbria, unsurprisingly, it kind of straddled the journey of Finch through from the High Court to the Court of Appeal to the Supreme Court. So the law was sort of changing dynamically as their inquiry progressed, unfortunately for them. So
it was the right answer when the decision was made, and the
yeah,
right
it
answer
was.
post Finch, wasn't it, effectively?
It was. So in Finch, in the High Court, so the High Court said that downstream emissions weren't capable in law of being something that needed to be assessed. And anyway, it's for the decision maker to decide what the scope of the EIA is, basically. The Court of Appeal agreed on the second point, so it said yes, it's for the decision maker, but it didn't agree on the legal principle point. And then the Supreme Court then subsequently said that no, downstream effects need to be assessed. So the inquiry in the Whitehaven case came, I think, just as the Court of Appeal case was being decided, and so the Secretary of State's decision letter was drafted, I think, with the Court of Appeal decision in mind. So the point really in Whitehaven was an attempt to distinguish Finch on the basis of what I'm going to call the substitution argument. And I mean, it's pretty simple to understand, although it's very technical in the judgment in terms of how it's expressed. Basically, what was being argued is that there were no likely significant effects of the development in terms of downstream effects, because the coal that would be extracted from the Whitehaven mine would substitute for other coal that would be extracted elsewhere, and the US was the focus of the arguments. So what the mine owners were basically saying is that coal from the Whitehaven mine would be used in preference to coal from the US. And what they basically advanced the argument on a sort of economic basis, based on economic principles. So there was no sort of real rigorous analysis of that, and it was it was not shown to a sort of sufficient degree that that would be possible. But the Secretary of State did accept that in their decision letter. In the High Court, I think didn't dismiss the idea of the substitution argument entirely as a legal principle, but just found that in this case it didn't work. Basically because the level of detail that had been gone into in the inquiry just wasn't sufficient to make out that argument. So what the High Court said is, if you could show that it was inevitable that there would be that substitution, then you might be able to make out that there was no likely significant effect, and so it could be scoped out at the EIA. But in this case, they just got nowhere near the required standard, and so the case was dismissed. I think if I was going to summarise the judgment, I would say what the court is really telling us here is just assess the downstream impacts, because although it's being left open as a matter of legal principle that we could run those kind of arguments, in reality, the way that you would get home on it is by effectively performing the assessment itself. So, in practical terms, I think for developers going forward, this is just something that's going to have to be, so downstream impacts are just something that's going to have to be scoped in, particularly where it relates to greenhouse gases. So anything that's being extracted and burned, the greenhouse gas impact of that is something that's going to be need to be assessed in future.
Yeah, I think it's an interesting case because it is you do sort of feel for everybody involved really, because the rules of the game changed as they were going through the process, which is always a challenge when you've got.
Well, they didn't have the evidence because they sort of didn't think they needed it. Because when they started, of course, it was as a matter of legal principle, and in the High Court, it was just not something that needed to be assessed, and then it sort of gradually shifted as the inquiry went on, I think.
And it's sort of
Ian,
sorry, Amy, you first.
Do you think there's ever a likelihood that someone might succeed with substitution arguments in the future? I mean, probably not greenhouse gases, but on.
Well, we were talking about this actually just before coming on, weren't we? I mean, I think so. I mean, definitely, both the Supreme Court in Finch and the High Court here, I think, have not ruled out that could succeed as an argument. I think when you look at the way that Mr. Justice Holgate sort of deals with the point in the Whitehaven judgment, I think he is essentially saying that you would need to be able to show that it's inevitable that there would be that substitution effect. And when you're dealing with things like global markets for commodities and so on, it just seems difficult to imagine a situation where really you might be able to demonstrate that. I think that the sort of situation that we thought maybe is if you had a mining company that already owned a mine that was maybe a dirty mine or something, it was going to close that one and open a new one, perhaps offered a Section 106 agreement or some sort of commitment that would mean that the first mine would close, and so there would be a direct one-to-one substitution. Perhaps you might be able to establish in those sort of circumstances, but I think you almost would need to be in control of both developments. I don't know what you think about that, guys.
Yeah, even that seems quite, I think, tenuous maybe, in that just trying to demonstrate that you're never going to use the first mine's coal, I suppose, is where you need to get to on that, isn't it? So
well, there would always be the possibility, I suppose, of removing the 106 obligation, wouldn't there, or amending it in some way in the future. But I mean, I guess we're only looking at sort of reasonably foreseeable effects, aren't we? So there's a limit to how far into the future we would need to look.
And I think that's an important point for me, because but firstly, I think this idea of substitution, it's almost impossible, to your point, Ian, unless you've got complete control of the other source, particularly in a global commodities market. You just are never going to be able to demonstrate that mining a ton of coal in the UK means that a ton of coal in the US stays in the ground. You're just not going to be able to do that. But I think this is a sort of slightly alarming principle, and certainly the way it was argued unsuccessfully in the High Court and the Court of Appeal was slightly alarming in this idea of downstream effects always needing to be assessed, because actually, how do you begin to calculate those downstream effects? So I think one of the sort of points that is there in Finch and isn't affected by Whitehaven is those downstream greenhouse gas effects only need to be assessed where there is an inevitability that they will arise and where you can calculate. And Finch made it clear it doesn't matter what the oil is used for and how it's burnt, whether it's turned into fuel or used in industrial processes or whatever, that the carbon emitted from it will be the same. It will inevitably be burnt, and the emissions will be the same regardless of how it's used. That isn't the case, I think, for beyond that sort of mineral extraction, fossil fuel extraction. That is rarely the case. If you were, I don't know, a manufacturer of cars, I don't think it's saying that the factory would need to assess the greenhouse gas emissions coming from those vehicles when they're used, because actually you just don't know how they're going to be used. You don't know how, you don't know what the effect's going to be. So I think there's still that limitation of there needs to be a certain level of certainty, I suppose, around what those emissions will be when the product leaves site before you have to start engaging with it.
Yeah, I mean the effects have to be likely, don't they? So it's not a lot of focus in that phrase gets put on significance, doesn't it? Well, are the effects significant? But the effects also have to be likely. So there is a bar. We don't have to assess any possible effects. We only assess those that are likely and significant. I mean, I think this is a developing area of the law, isn't it? So I mean, I don't think Finch sort of rules out the sort of scenario that you're describing there, although it doesn't rule it in either, does it? So I mean, I think there will inevitably be some cases over the next few years on this point about what are the extent of downstream effects that need to be assessed, and also things like upstream effects actually, because I mean there are situations, aren't there, where developments can be said to sort of create demand. So I mean, this is an idea in so highway schemes, for example. If you build a highway, you actually create more demand because there's more capacity for people to use the road. Now those effects would be assessed anyway as standard practice, wouldn't they? But I can think of other scenarios where you might argue that building some infrastructure might then enable I don't know, the connection of a power station to the national grid or something. It's those kind of situations I think that might be tested in the future.
I agree with that. I think while the Finch judgment is limited, it's that there is that thin end of the wedge, and the organisations sort of concerned with climate change and who are pushing this litigation, and we're seeing much more climate related litigation, not just in planning but across the piece, really, aren't we? That principle will continue to be tested and will continue to evolve. So it is something that I think people need to be aware of, particularly if you're getting objections to your application on that basis. You need to be getting some very good advice around how to approach that ES, and probably take quite a cautionary approach in order to avoid being caught up in litigation subsequently.
Yeah, I mean that's the pattern of development of environmental law, isn't it? That these topics are explored fully, and it will take probably another couple of years for us to really find what the limits are. But I mean, just a sort of final word. I mean, this is obviously something, if the government's got an eye on delivery of infrastructure and sort of development generally. I mean, this is something that is within the government's control to a certain extent, isn't it? Because I mean, Finch is a post-Brexit UK decision. So I think that the government could amend the EIA regs to make this clear, what exactly is in and out. So if it wanted to limit the scope of the effect of Finch, then it could do by amending the EIA regs, as I say. And I don't think that would be a case of backsliding in terms of EU law, because I don't think this principle existed in EU law before Finch. I think it is a sort of it's a homegrown application of the principle anyway, put it that way. So, I mean, if the government is, sort of minded to help, I think that could be something that it should look at.
No. I haven't seen any evidence of that. There's been no suggestion that they're thinking about it, but they're probably quite busy at the moment with other things. Rewriting the MPPF, for example, it's imminently due out, isn't it?
Indeed.
Amy, shall we move on? West Oxfordshire we're going to next.
Happy to. The case I looked at involves a judicial review of a Section 73 permission. It's all to do with timing. So there's quite a complicated timing history, which I will try and explain for everybody, and then explain what that means in the context of Section 73s and pre-commencement conditions. So going back to January 2020, planning permission was granted for residential development with supported living in the West Oxfordshire Cotswolds. It had a condition that it had to be commenced within 3 years, and it was subject to a number of conditions, including 3 commencement conditions. So these pre-commencement conditions required the approval of matters to do with a buffer between the development and an ancient woodland. So they had to have a buffer of 5 metres between the development and this woodland, and there was also a tree protection plan and other sort of similar issues, but it's this 5-metre buffer that causes the problems. So fast forward to January 2022, the developer applied to discharge these 3 pre-commencement conditions. However, the claimant for the judicial review, the Friends of the West Oxfordshire Cotswolds, recognised that there was a inconsistency in the plans that were approved by the original planning permission and the plans to discharge the pre-commencement conditions. And this inconsistency basically meant that it wasn't possible to provide this 5 metres boundary on the terms of the plans that were approved by the original planning permission. So even though the plans to discharge the pre-commencement conditions purported to do so, they couldn't because they conflicted with the plans secured by the planning permission. The developer recognised that this was the case and said that they were going to submit a Section 73 application which would deal with this inconsistency. But at this point, they didn't do that. So August 2022, the pre-commencement conditions were discharged. So that discharge was approved by the council. Then in September, the claimant, the Friends of West Oxfordshire Cotswolds, JR'd the approval of pre-commencement conditions. So from that point onwards, it was known that there was a question mark over the pre-commencement condition approvals, and that there was a potentially they could be quashed and returned to the defendant council for redetermination. However, just after the approval of the PCCs, the developer undertook some material operations relying on their application to approve the pre-commencement conditions and that approval, so that they could commence prior to the expiry of their 3 years, their planning permission. So that was all done. We would all hope that they'd lawfully commence. They still hadn't made theirs.
On your hearing, and there's definitely a but that's about to happen.
Yeah. So they still hadn't made their Section 73 application. So that they then made in November 2022. And that should have reconciled this issue with the 5-metre buffer. So it would have reconciled the plans on the original permission which would then have enabled this buffer to go between the development and the ancient woodland. And then the approval of the pre-commencement conditions would have slotted into that section 73, and it would have all been fine. So we reached the deadline of commencement in the January. Obviously, they had commenced in reliance on the approval, which is now in JR. And then in March, the council granted the Section 73 permission. At this point, the JR of the PCC still hasn't been heard. Later in March, just within a week, maybe 2 weeks of the Section 73 grant, the approval of the PCCs is heard and the PCCs are quashed. They were remitted for redetermination, but actually they couldn't be redetermined on the original planning permission because that reconciliation of the plans was never going to work. So in effect, there was never going to be that approval of the PCCs from the March date onwards. So then we get to the hearing of the judicial review for the Section 73, which was launched in between. And then in September 2024, the judicial review of the Section 73 quashed the Section 73. So the quashing of the Section 73 was based on a number of grounds, but one of the most sort of pertinent grounds is that under Section 73(4), you can't make an application for a Section 73 variation if your development has expired. So the original permission had expired because the PCCs were never granted. Now, the PCCs were obviously granted, but then quashed. Now, the case found that because they were quashed, they were never lawfully granted. That wasn't known until that first JR of the PCCs. So, confusingly, in a way, the case decided that the Section 73 that was granted could have been okay, but it wasn't from the point that the PCCs were quashed. So there's a lot of complicated timing issues here, but it does decide that that approval or the quashing of that approval of the PCCs had retrospective effect, and therefore there was no valid outline permission at the point that the Section 73 was granted, and therefore the Section 73 couldn't be granted. So everything was lost at that point.
When I read this case, Amy, I just thought we should have reviewed it last month on Halloween, because it just absolutely made my blood run cold. It's I mean, it's quite a unique set of circumstances, I think, isn't it? But I mean, poor developer.
We said there was no theme, or I said at the beginning there was no theme today, but actually maybe the theme is getting screwed by strange judicial timeline.
Because there is a link, isn't there, back to Ian's case, that Ian's case had the timings run differently. They would have considered Finch differently at the point that they undertook their EIA.
And in that case, that application for planning permission had gone in about May 2017. So I mean, you would sort of hope in a well-functioning planning system that it would have been determined before Finch got to the Supreme Court in summer 2023.
In a what? That was a concept I've never heard of before. A well-functioning planning system. Gosh, one day we can but dream. I think there's an interesting. Yeah, it is an unusual set of facts, but there is a warning there for us all, isn't there, about timing of these things. Your Section 73 was granted, it was perfectly valid, but then suddenly it gets quashed because of a challenge to the pre-commencement conditions. It's just when and I think you sort of alluded to it when you said they said they were going to bring a Section 73 forward at the time and they didn't. I guess they kind of, I don't know, for whatever reason they didn't. But actually, if they'd have done it at that point and got it all done in time,
Yeah.
they'd have been all right. But having sort of decided to let it slide or see if they got away with it or whatever, by not regularizing the position up front, in the end they lost everything, and that's it seems to me that's the warning, isn't it? Is don't leave these things until they become necessary because of legal challenges. That challenge could have been seen off if it had all been dealt with a little bit more proactively and a little bit earlier on in the process.
Yeah, they must be kicking
Completely.
themselves because the judgment makes it really clear that before the PCC approval, the developer had said it was going to put in a Section 73 application. So they knew about the issue. They just must be kicking themselves that they didn't do it earlier, and that.
And one of the most common things that we will deal with when doing sort of due diligence and things like that is pre-commencement conditions and whether they've been discharged and all those things. I know, from sort of conversations with clients, sometimes they can seem like quite sort of arcane legal points, but I mean this is a really good demonstration, isn't it? If your pre-commencement condition is not discharged properly, and I mean I know in this case it was quashed, but that could be anything, couldn't it? That means that has not been discharged or not been discharged correctly. You could lose your planning permission, and that's what happened here. So it just really underlines that point. I think that pre-commencement conditions are really significant, making sure that they're discharged properly. Like you say, Trevor, being proactive and just managing that discharge of condition process, because you can unintentionally lose the benefit of planning permission quite easily if you're not on top of things. Particularly complicated developments, could have hundreds of conditions, couldn't they? So it is a task to keep on top of that.
And also, I think it sort of underlines that just to be on top of inconsistencies, because this is where this all came out from, an inconsistency of a plan, which sounds like such a minor issue in some ways, but it wasn't, because they couldn't do what they had to do. Then it's thrown the whole development. So I suppose to me it's about two things. It's about timing, but also sort of just having an eagle eye on what you're putting in, because that it sounds such a simple thing that your plan was slightly out and you couldn't quite get to the 5 meters somewhere, but it's lost you permission. So yeah.
And that segues quite neatly into the case I wanted to talk about, because that's all about plans and the importance of plans in the context of planning permissions as well. So the case that sort of jumped out to me is the case of Ario. And I should have said at the beginning, we'll circulate for everyone the details of the cases, so that people can read them at their leisure if they wish. Although trying to read the timeline in Amy's one is a challenge, so to only do that if you're suffering from insomnia. But the Ario case is on the face of it a relatively minor development, but I think the principle is a really good reminder of something that we all need to do, which is to always keep an eye on the plans that are approved as part of a planning permission. So the challenge was to a decision of Richmond upon Thames Council. They had granted planning permission for a structure to be erected in the garden at the rear of a restaurant. It was a sort of covered structure, so you could all-weather dining and all that sort of stuff could happen in the garden of the restaurant. Now the restaurant was in a building that was a sort of old-fashioned style parade of shops. So it had originally been a hardware store, and it was one of those parades with flats above, that sort of mid last century sort of shopping parade type style development. And back in 2005, there'd been a planning application. So this is long before Use Class E existed. There'd been a planning application to change the use of the hardware store, or change the use of the ground floor of this building from hardware store, which would have been A1 at the time, to a restaurant, which would have been A3 at the time. And that planning permission was granted. So the description of development solely referred to the change of use of from hardware store to restaurant, made no reference to the backyard of the hardware store, which, whilst it was a hardware store, seems to have been used for sort of growing plants to then sell in the hardware store. No reference to that outdoor space, but the red line extended to the whole area, both the hardware store itself and the yard to the rear. So that had been the historic position. This planning permission for granted, restaurant been operating, and the restaurant had been using the garden. There was seating out there, so presumably during the summer, there'd been outdoor dining. Then more recently, in comes this planning application for this covered structure in the garden in order to facilitate this all year round dining al fresco. Mr. Ario, I don't know if he lived directly above or if he lived nearby, but he was in one of the residential units above and was unhappy, and particularly around issues around noise and amenity. So he challenged the grant of planning permission for the structure, and he challenged it on the basis that the garden didn't have permission to be used as a restaurant, because the description of development on planning permission had only referred to the store, not to the garden. And so when the council had made the decision and they'd considered issues like noise, what the officers' report had said is, well, look, the principle of this development is already established. This is already allowed to be used as a restaurant garden. Therefore, that principle is already established. Therefore, these matters are sort of too late. The noise coming from operating as a restaurant has gone, and Mr. Ario challenged that, as I say, on the basis that the description of development didn't include reference to the garden. The court disagreed with that. Now, actually, the court went on in the end to quash the permission nonetheless, on the basis that what they said was, well, whilst we disagree, and I'll come back to why they disagree, because that's the interesting point, but just to sort of finish the story, what they said was the reason, yes, the garden was in restaurant use, but actually the council had failed to consider the question of whether this structure, which was presumably going to permit an intensification of use, certainly in terms of it becoming more usable 12 months of the year rather than just in the summer months, whether that would itself have increased noise and amenity impacts. And they hadn't considered that. They hadn't taken that into account. So in the end, the court said, well, there was a failing. But I think the interesting point is this point that they looked at the planning permission and they said, well, yes, the description of development only relates to the store, but the red line goes around the whole. And when you're looking particularly at a full planning permission, the question of what is permitted by that planning permission is not just a case of looking at what the description of development says, it's also a case of looking at what is on the approved drawings. And the fact that something isn't referenced in the description of development does not mean that you're not consenting it with that grant of planning permission if it's shown on the drawings. So in this case, they were very comfortable that that planning permission did include a change of use of the garden to restaurant use. And use ancillary to that primary use of the ground floor of the building as restaurant. I don't think there's anything new in that. There have been many cases before that have looked at it, and certainly I was involved probably about 15 years ago with a case in Stevenage involving the Roaring Meg retail park, and that one there was a sort of issue there where an existing retail unit on a retail park that had been consented in the 80s, that had a sort of usual bulky goods condition restricting sort of what could be sold from the retail park to bulky goods in order to protect Stevenage town centre. Over the years, lots and lots of changes and lots of planning permissions. And one of the planning permissions that had been granted in respect of a particular unit was a planning permission to subdivide the unit. And so actually, all that was needed was planning permission to change the frontage, to put two shop fronts rather than the single shop front. But the red line had included the entire unit and had shown certain works, sort of the internal wall and things, none of which technically needed planning permission, but critically it had gone around the whole unit. Come the global financial crisis, my client struggling to let the unit, getting creative as to how to extract value from this unit, and an application for a certificate of lawfulness went in saying, well, actually, the planning permission for the subdivision is a planning permission in its own right. It's for the whole of the building, and there is no bulky goods restriction on it. Therefore, we can sell whatever we like from it. We've got open retail here. It was rejected by the local authority. It was approved on appeal by the planning inspector, and that was challenged by the local authority, and it was upheld in the High Court as well, on that same principle that the planning permission is not just for what the description of development says. The planning permission includes what's in the plans. So I think kind of the takeaway for me from this is always be alive when you're looking at whether you're a local authority determining a planning application. Have an eye on the plans, because you're granting planning permission for whatever on those plans, as well as what's in the description of development. But also as a landowner, have an eye on those plans, because they will inform this scope of the planning permission as much as the description of development, which I think is something that, as I say, I don't think there's anything new in the case, but it's a good reminder of a principle that quite often gets overlooked, I think, in my experience.
Yeah, I mean, there's a legal principle point in there, which is just, you need to be aware of that. But there's a attention to detail point as well, I think, isn't there? Because I think, sometimes, sometimes there are version control issues, or, perhaps it's just not properly been appreciated what is in the plans, or other supporting documents as well that are incorporated into the permission. You have got to be aware of everything that is coming within the scope of the planning permission. Basically, it's not just that description of development, as you say.
Yeah. So I think an interesting one. But yeah, keep an eye. And I think it's always interesting. You sort of see sometimes you can sneak something in, put it on the plans, but don't refer to it in the rest of the documentation. And if a local authority doesn't spot that, they've granted planning permission for what's on those plans. You see it quite a lot with residential, I think, don't you? Where there was a line of cases many years ago where sort of extensions to houses and things, but at the same time the red line shifted out into the adjoining field, and then sort of an argument that actually, oh look, the curtilage of my garden has just moved and incorporated this field. There's been a change of use, and potentially those sorts of things can happen. So you've got to always be alive to those plans. But equally, if someone's telling you haven't got planning permission for something, you need to be alive to those plans, because the solution may well be on the plan rather than in the description of development or elsewhere.
I mean, general point in work in life, I say this quite frequently to the sort of junior lawyers. In work, it's an absolute superpower to be the person who reads everything, because not everyone does.
You're giving away your superpower now. Everybody knows.
Yeah. Well, it's not a superpower. If it's accessible to everyone, it's not really a superpower, is it? But you know what I mean.
No, it's definitely a secret weapon, isn't it? But that's the one who is most prepared, the one who knows the papers most, is always in a better advantage, whether you're in a judicial review, an appeal, or just dealing with planning in the first instance. Actually, if you understand what's going on, you're ahead of quite a few people in the room quite often.
Agreed.
We've got one more, which is a sort of slightly the case itself, I'm not sure is terribly interesting, but there's a interesting principle that comes out of it, and a timely reminder, which is the Thomas case, which was in Cheltenham. It relates to an application for request for prior approval for a new mobile phone mast. I thought mobile phone masts had stopped being controversial, but when I said that at a talk I was giving the other day, I was told very clearly that is not the case. Apparently, people do still object to mobile phone masts. So, but actually, the fact it's mobile phone masts is irrelevant to the point I wanted to make. But the applicant puts in their request for confirmation as to whether prior approval is going to be needed under the permitted development rights. That application was accompanied by a certificate, and I'm going to have to read this because I can't do it without reading. So forgive me, I'm going to have to look down. But the certificate was a certificate of compliance with the radio frequency public exposure guidelines of the fantastically named International Commission on Non-Ionizing Radiation Protection on the Limitation of Exposure of the General Public to Electromagnetic Fields. Got that? I hope you have. So certificate of compliance to say they comply with these guidelines around EMFs, electromagnetic fields, which is has always been one of the big concerns with mobile phone masts, hasn't it? Lots of objections come in from the public, most of them based on concerns around EMFs. And the local authority points to the NPPF, which says it's not the role of the planning authority to question those guidelines, their name check specifically. It's not for the local authority to question those guidelines. We assume those guidelines are correct. And so on that basis, they said there was nothing in these objections, and therefore they said they didn't require prior approval, and the mast was erected. Mr. Thomas was one of the objectors, and he'd objected on a slightly more sophisticated basis than the rest of the objectors, in that he'd objected on the basis that there was a retirement housing development nearby. And he said that the EMFs had the potential to have a harmful impact on hearing aids and medical devices. And the fact that there was a retirement housing complex nearby increased the likelihood of there being hearing aids and other medical devices. That had all sort of got swept up by the local authority in saying the answer's in the guidelines, so we're not going to look at it. Mr. Thomas was unhappy with that, challenged, and his challenge was successful. And the reason his challenge was successful was because the guidelines themselves, if you actually read I'm not going to repeat the line, but if you actually read the rather long titled guidelines, the guidelines themselves recognize that EMFs could, not do, but could have a harmful impact on medical equipment. And then the guidelines go on to say that such matters are outside the scope of the guidelines. So they say we're not going there effectively. So the court, unsurprisingly, said, well, hang on a minute. You, local authority, can't rely on the guidelines to say there's no merit in this concern regarding impact on medical devices of EMFs, when the guidelines themselves say we don't consider the impact of EMFs on medical devices. And so for that reason, they upheld the challenge and quashed it. As I say, a really specific set of circumstances there. But I think that what I take away from that, and I think we all see this quite a lot. I can see you nodding already, and you know where I'm going. If you are going to rely on guidelines to justify your position, make sure the guidelines actually say what you need it to say, because it's so easy to say, oh, it's it's in the ES, or it's in the MPPF, or it's in these guidelines published by the WHO, or whatever it is. But it's a mistake not to actually go and say, well, where is the line that I need to rely on? Because if it's not there, you're creating a real legal issue for your planning permission, if that planning permission is granted in reliance on guidelines that simply don't say what it is that you've said they say. So whether it's highway standards, whether it's environmental standards, whatever it is, if you're going to rely on published guidelines to say you don't have an adverse effect, you need to actually pick up the guidelines and find the line and say, oh, yes, there it is. Because otherwise, if it's not actually there, you just end up at a legal mess afterwards. I think is my takeaway. Always read the guidelines if you're going to rely on them.
Yeah, I mean, I've had a couple of cases like this in relation to the planning practice guidance, actually, particularly. So it's same sort of issues where it's been asserted that such and such a point is in the planning practice guidance. Actually, when you go and look at it, if you can't quite find that point, and I think the thing is, so much of planning is done on a sort of custom and practice basis. Yeah. You know what I mean? And so it's kind of it's people in some ways sort of summarising what they've heard or what they think they remember from the last time they read it or whatever it is, and it can cause real problems, as you say.
Mm.
All comes back to one theme of attention to detail.
There it is. Attention to detail. Yeah, it's true. It is. It's just, and I think it's part of our job as planning lawyers. And I know it sometimes irritates sort of planning consultants or other consultants when we're reading their reports and we say, well, where? You've just said it's in DFT guidance this or DEFRA guidance that. Where is it written down? And you can sort of see the kind of really. But it's interesting the number of times when you ask that question, when they go and look at it, they'll come back and, well, actually, that's not quite what it says, is it? So it is a constant theme, I think, for us of where in your ES have you assessed this effect and made this conclusion? Where have you set out what the mitigation is? And this is just I sort of feel vindicated in my approach of constantly pushing people to show me the words, not show me the money. show me where it's written down, because if you don't, you can get into those sorts of mistakes. And who wants to spend all that money getting their planning permission only to have it quashed because the guidance you're relying on doesn't actually say what you said it said, and nobody thought to read it and check. I paused there, Ian. You look like you were going to say something. Otherwise, I was going to round up.
No, I think I was just agreeing with you.
Good. Well, I started by saying there was no theme. Maybe there were two potential themes that came out of today. One is that unluckiness of the court process overtaking you, and the other is attention to detail. Always look for the words. And we always try to be under an hour. We have actually managed it. Normally we run quite close, but we've managed it today, so that's good. If I can just, firstly, Amy and Ian, thank you for joining me. Everyone who has joined the live broadcast, thank you. As usual, this will be available as a recording on our YouTube channel within the next few days. So do feel free to draw it to your colleagues' attentions if you think it will be useful to them. Otherwise, we always tend to take a break around Christmas because, frankly, everybody's got more fun things to do in December than listen to us talk about planning. So we will be back in the new year with the next edition of Outline. But in the meantime, do all enjoy. I know this is very early, and hopefully I'm the first person to say this to any of you, but do have a happy Christmas and look forward to seeing you all again in the new year. Thank you all very much.